Sorry.
Get to activate my.
I see it. Sorry, I messed things up.
Sorry, I just want to be able to activate. All right, we're going to get started. Thank you for joining us this afternoon. I'm going to. Yep. What do you need? Hold on. Lenny needs. This is the unusual moment where Lenny needs help from me. This never happens.
I'm sorry. Thank you.
Okay.
I got too
Now
excited.
there you go. Okay. So I'm going to dispense with introductions because you all know Professors Porter, Manheim, and Lombardi. They have a great deal of experience, obviously, in constitutional law and also with the Supreme Court. It's not hyperbole to say that we are today standing on the edge of history. I mean that literally. U.S. versus Nixon, Bush versus Gore. This is a case that will be decided by the Supreme Court, and I absolutely guarantee that we all will have it in our minds for the rest of our lives, no matter what happens. Tomorrow, the Supreme Court is going to be asked to decide whether, based on credible allegations of conduct constituting insurrection, the currently leading Republican candidate for the office of president can, as a matter of constitutional law, appear on the ballot in November. Needless to say, it's not a question we have ever had to think about before. So, Professor Porter, you'll all enjoy this. This is a chance by which I get to cold call all of your professors. The worm has turned. So let's start at the beginning. Professor Porter, how did the Colorado case get started? Who were the plaintiffs and what claims did they bring?
Okay, well, before I explain the actual filing of the lawsuit, I just want to note that after January 6th, there started to be kind of some talk by legal scholars that maybe Donald Trump was qualified for rerunning for office based on Section 3 of the 14th Amendment. And in particular, then, two quite conservative sort of Federalist Society associated legal scholars, Will Bode and Michael Paulson, wrote an article that's actually forthcoming, kind of analyzing the original source material. And it basically kickstarted a conversation about this part of the Constitution, which we actually have never considered. It was never mentioned when I was in law school. We just didn't look at it. It has not really been used because there wasn't a kind of shadow of insurrection at any time. So inspired perhaps by that, 6 Colorado electors, voters, some Republican and some unaffiliated, together with CREW, the Center for Responsible Ethicals in Washington. Yeah, I have it written down someplace, filed a lawsuit seeking an injunction against the Colorado Secretary of State, Jenna Griswold, barring Donald Trump from the primary ballot in Colorado on the ground that he was unqualified under Section 3 of the 14th Amendment. So this original process was like a kind of administrative process in some ways, right? They didn't sue Donald Trump, right? They were just seeking under Colorado election law to exclude him from the ballot. Donald Trump intervened. Then pursuant to this Colorado law, the Colorado court held a 5-day trial or a 5-day hearing. I don't really think you could quite call it a trial. And the court concluded, the District Court of Colorado State concluded that Donald Trump should stay on the ballot. The district court agreed with many of the arguments made by the electors and CREW, the plaintiffs. However, the district court held that, so that we could go at length, Donald Trump is not, Trump is not he's not included. The president, the office of the president is not included in Section 14. That went up to the Colorado Supreme Court, which disagreed on that issue. And if you think about this, it's Colorado metaphor. Colorado Supreme Court skied down this diamond hill of constitutional issues and held that Trump should not be on the ballot. And then stayed its decision so that Trump and Griswold could potentially petition the Supreme Court, which they did. So this has all happened. I mean, if you think about this from a civil procedure perspective, like for me, this gives me vertigo. This is all happening under an incredibly compressed timeline using state procedures that were not intended to deal with insurrection.
Professor Manheim, we know the Colorado decision was not unanimous. What did the majority and dissenting justices say about these issues?
Yeah, thanks. So Professor Porter says that this is giving her vertigo as a matter of civ pro. This case gives me hives as a matter of election law. So okay. So the question is, what did the Colorado Supreme Court hold? And I'll get to that in a second. But before we even get there, sort of in terms of where we are in the election process right now, when the United States, voters in the United States vote for president, it is an extraordinarily complicated process, as most of us are aware. And part of that is because we have states running separate elections for a national office. And in order to translate those different states' votes into, one single winner across the country, that sort of translation process is, again, really complicated as a matter of law. It involves the Electoral College. But actually, we're not even there yet. We are in the stage of the process where the two major political parties, and here we'll just talk about the Republican Party is trying to figure out who its nominee is going to be for the general election in November. And in order to do that, we have within each state some sort of process for figuring out who the nominee is going to be. It's largely dictated by state law, and it's very different from state to state. So some states are going to have caucuses, some states are going to have primaries, some states like Nevada are going to have both, apparently. It's really, really complicated, and it not only involves each state's laws, but it also involves the rules of the political party. So the rules that are governing who gets to be on the general ballot, right? We're not even there yet. We're talking about the rules governing who gets to be on a primary ballot. And those are, to repeat myself, incredibly complicated, and they vary from state to state. So right now, what's at issue in this case is the rules governing who is going to be on the Colorado primary ballot. Okay, so that's the specific question that the Colorado Supreme Court is answering. So you asked, you said it's not unanimous. What did the court hold? And again, just as a theme in this litigation, if the question is ever, was the analysis simple? The answer is always no. And did anyone agree on it? The answer is always no. So we're going to predict accurately that in the Colorado case, we have a dissent. And with respect to the majority opinion, as Professor Porter said, there's all these different legal questions that you have to answer in order to get to the conclusion that, yes, at the end of the day, Trump needs to be excluded. And so the Colorado majority answered them all, yes, 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 yes. And we'll be talking about a number of those different issues. The dissent, there were 3 dissents. 2 of them essentially said, as a matter of Colorado law, we should have not decided this question in this way at this time. And that feels kind of like a technicality, but actually those sorts of considerations complicate this case quite a bit as a matter of election law, which at the end of the day, that's what we're talking about. The third justice decided it on a different ground. And essentially, there's all these different phrases that are being used, things like, is 14.3 self-executing? Is there a political question doctrine involved, et cetera? All of these kind of can be wrapped up to say in a packaging where the conclusion ultimately is, hey, Congress needs to act here. So that's what the other justice in the Colorado case decided. Congress needs to act here. And without Congress acting, it's improper for Colorado to exclude this person from the ballot.
So I'm going to go to Professor Lombardi next, but just a quick question.
Yeah.
Thinking about the dissenting justices, the 2 that you just referenced, is it conceivable that the U.S. Supreme Court would render a decision that says the Colorado Supreme Court misinterpreted Colorado state law?
Great question. It is possible that the U.S. Supreme Court would decide that this case the decision needs to be vacated and the case needs to be remanded to the Colorado courts because Colorado made an error of law regarding Colorado law. Now, here's the thing, for any of you who have taken federal courts, or for any of you who paid a lot of attention in con law or civ pro, you might think to yourself, that doesn't sound quite right, because generally speaking, the US Supreme Court is not supposed to be telling a state court how to understand state court law. Have any of you heard of the independent state legislature doctrine / theory? Yep. So the Supreme Court, in theory, decided fairly recently that this idea that sometimes the US Supreme Court should sort of second guess the state courts, the Supreme on questions of federal election law. The Supreme Court recently sort of concluded that that doctrine does not give the Supreme Court the power to make those sorts of decisions, except in some cases. So the question is this one of those cases where the US Supreme Court would second guess a state Supreme Court on state law? So again, we don't know. Remember, that's always the answer. I know.
Okay.
Nobody agrees.
All right, so now to Professor Lombardi. So before we dive into the specifics of this dispute that's going to be heard tomorrow, I want to take a look at section 3. Hold on. I'm going to put it on the screen. There we go. All right, section 3 of the 14th Amendment. Can you tell us, has this ever previously been used to keep a candidate off a ballot?
So I should also say, I get hives too, but I get hives from a comparative constitutional law perspective, because so I study the US Constitution in comparison with other constitutions, and there are a number of countries in the world whose constitutional courts or Supreme Courts are permitted to ban candidates from running for president or office. And people always ask me, what's it like in the US? I say, well, you can't do that in the US. We've never seen it. And then I realized maybe I spoke too quickly. In any case, looking back then, historically, the answer is no, it's never been used to keep a candidate off of ballot, but it has been used to remove people from offices that they're currently sitting in. And to understand that, we'll need to do a little bit of history. So the 14th Amendment was enacted in 1868. And as you can see from in the language here, people are barred from, a person who's engaged in insurrection is barred from serving in office unless Congress removes the disability. And in 1872, so in 1868, the 14th Amendment was enacted with the understanding that it would ban an enormous number of Confederates from serving in the federal government. And in fact, in the intervening 6 years, 8 Confederates were removed and a number voluntarily left office. And it's pretty clear that a number of people didn't run for office because they believed that either they would be prevented from running or they would be removed upon taking office. But then in 4 years, in 1872, Congress enacted a blanket amnesty. So Congress acted to remove the disability from an enormous number of former Confederates. And at that point, the disability was removed and Section 3 disappeared from litigation and conversation until recently. Now, there has been, in the wake of January 6th, there was one county commissioner in New Mexico who was removed from office by the New Mexico Election Commission, and that was upheld last year by the New Mexico Supreme Court. So there has been one person removed as an insurrectionist from office in New Mexico for the on the grounds that they had engaged in insurrection during January 6th. That case has been appealed to the Supreme Court, and the Supreme Court has not decided whether or not to take certiorari. And depending upon what happens in this case, then maybe they'll take cert in that as well.
How do you size up the difference between that individual having been criminally convicted for insurrection versus President Trump having been found to
He
fallen
wasn't,
within this statute as a consequence of this 5-day hearing.
yeah, well, no, but he wasn't criminally convicted. He also, there was a hearing, there was a hearing in front of the New Mexico Electoral
Got it,
Commission,
okay.
and they removed him from office on the basis of that. In fact, he had less of a hearing than former President Trump had in Colorado. And the New Mexico Supreme Court said that the hearing was consistent with hearings that had been held to uphold, for example, the age limits for candidacy. And people have been barred from running for office on the grounds that they are not natural-born citizens or that they are too young to serve in the office. And because the hearing that had been held for this county commissioner was as involved as the hearings that have been held in those other circumstances, it didn't violate due process. And
Got it. So, Professor Porter, there are, as we are quickly seeing, a great constellation of issues that are embedded in this case. When the Supreme Court accepts a case review, typically it narrows or defines the question that's going to be decided. How did that occur here? How did the Supreme Court narrow the question to be decided?
In a way that should give everybody pause, it didn't. The question presented, filed by the petitioners, was simply, did the Colorado Supreme Court err when it refused to put him on the ballot, Trump on the ballot? And the respondents tried to say, like, actually, why don't we catalog this into some actual questions? And they suggested 7, which is too many anyway, right? 7 questions presented. No, court didn't go with it, which means that when we're considering all of these questions, we actually don't have any insight into the questions based on which the court will rule. It's one of the things that's, I think, really difficult about this case is how do you know what the stakes are when you don't really know which legal question the court will focus? That's just where we are.
So everything's fair game, seemingly. So, Professor Manheim, let's get into some of these specifics. Is there a dispute legally about what it means to engage in insurrection?
So what it means to engage in insurrection. This is a federal question. And what that means is that in theory, as a matter of sort of formal law, there is an answer. There's an answer to the question, what does it mean to engage in insurrection? And on, if the facts were settled in some way, or if we had factual findings to defer to, then again, in theory, there is an answer to the question. Does what Trump did, does it constitute engagement in insurrection? Yes or no? So again, as a formal legal matter, the Supreme Court should be able to provide guidance on that. And again, if to the extent there are factual findings that it can defer to, then the Supreme Court should be able to give us an answer to that question. However, there are no precedents on this that sort of give us clear guidance on exactly what it means. Normally when it comes to a legal question like this, there would be what's called percolation through time. So there would be courts and others that have sort of asked this question and answered it, sort of giving us some sort of case law or whatnot through time. We don't have that here in the same way. So instead, what one has to do is sort of go to the precedents that are out there that aren't binding, that aren't sort of directly sort of determinative of the issue in a way that we might normally have. Now, with all of that as background, ready? Tellingly, no one's really arguing here that what happened on January 6th isn't insurrection, or to state that the other way, everyone essentially is conceding that what happened on January 6th is insurrection. And then when
Except Trump.
Well, yes and no. Yes and no.
In the reply brief.
In the reply brief, right. So the respondent's brief said, look, even they're not arguing that January 6th was an insurrection. And the reply brief, they're like, it wasn't that big. But when it comes to the question of did Trump engage in insurrection, the answer to that question requires a little bit more of sort of a sophisticated analysis of exactly what engagement means in this context, as well as, frankly, some need to get further into the facts, because it's not as sort of on the relevant facts aren't on the public record in exactly exactly the same way. That being said, again, I'm going to sort of repeat myself, which is to say, in this context, which is to say that the arguments that are being put forth the most forcefully in Trump's favor are not about whether he engaged in insurrection. His lawyers and their lawyers for the Republican National Committee seem to think that that is not the strongest argument to win on. Let's put it that way.
Professor Lombardi, does Section 3 provide any guidance on who gets to make that determination about whether a candidate has engaged in insurrection and what's required for the process? Is it possible this case goes south just because of procedural reasons, that the Supreme Court doesn't like the way Colorado reached this decision, irrespective of the result?
Can I ask you to rephrase that
Sure.
question? Sorry.
Does Section 3 or anything else provide guidance as to who gets to make that decision, whether it has to be a judge or a jury or a county clerk or the Secretary of State? Any guidance on who gets to decide whether a candidate has run afoul of this section, or the process by which that determination is made? How much due process an individual gets in that kind of an inquiry?
No, well, you can read the language. It doesn't do so on its face, and so one of the questions that people are trying to dig out of an entirely incomplete set of precedents is to address exactly this issue. So there has been an argument that, in fact, and it's an argument that was made by former President Trump and the committee, that in fact the disability that's mentioned here, the inability to serve in an elected office, doesn't come into being unless Congress has defined the circumstances under which the disability is supposed to arise. The theory is that this disability is not self-executing, but Congress has been given the power to describe the types of events that will make it impossible for you to serve in office and the types of procedure that can be used. And there is one precedent from the 19th century which makes clear that one justice on the Supreme Court in the late 19th century did believe that was the case. That's the only precedent we have. It seems to be inconsistent with the specific language. So the language says people can't serve, and it defines the people who can't serve as people engaged in insurrection. And given that the courts have the power of judicial review, they are the people who are supposed to define what insurrection is. And because we have a due process clause, it requires that any penalty imposed by the government be done using adequate and fair procedures. The courts are supposed to decide whether or not the procedures, whatever they were, that were used to label a person an insurrectionist, incapable of serving, were sufficient.
Professor Porter, let's pivot to a different issue. Let's assume that we, or the court, can agree on what insurrection means. We know that there's a question that's been raised about whether Section 3 of the 14th Amendment applies at all to the presidency. Section 3 is specific in precluding individuals who engage in insurrection from serving as a senator or representative. It doesn't specifically call out and state or identify individuals that cannot serve as president. Closest we get is to a prohibition on serving as an officer of the U.S. So tell us, if you could, why is Section 3 framed that way, and how strong is the argument that this section of the Constitution actually does apply to candidates for president?
So the first question, why is it framed this way? We're not sure. We don't really know. There was a point where the word president was in this draft of what became this amendment. And some people argue that actually they took it out because everyone said, yeah, of course, he's an officer of the United States. Duh, or the equivalent of duh in the 1860s. And then other people are saying, no, actually, very specifically here, the other major elected officials, senators and representatives of Congress, are listed. And the other United States, all the other officers of the United States, this bucket, actually, if you look at other parts of the Constitution, does not include the president. The president is an elected official, not counted within the officers. So for example, in the commissions clause, all the officers of the United States have to be commissioned. Marbury versus Madison, you get your piece of paper or you don't. And the president actually does the commissioning. So the president can't be one of those people because in theory, the president can't commission themselves. And there's a bunch of this terms, some variety of this term is used in a bunch of different places in the Constitution. So the answer is it's not clear. And there are reasonable arguments on both sides, both looking at the kind of originalist sort of legislative history, even though legislative history doesn't always indicate, and looking at the text of the Constitution, some of which was drafted at the time of the founders and some of which was drafted sort of post-Civil War, right? And then there's the question of how we actually would interpret that today. I just want to point out, though, that this answer, if the Supreme Court rules, and everyone's leaning into this argument, and I think the reason is that if the court rules on this basis, says like, oh, this doesn't include the president, and you're going to be hard pressed to argue the other way 100% because no one can, right? So it's excising Trump from this part of the Constitution right now, solving the problem on a nationwide basis, but it still allows Griffin, the guy in New Mexico, to get booted. It just doesn't answer that question. One of the things that's hard about this case is we're taking this incredibly loaded situation and answering all these novel questions that we might answer differently if it was just somebody who was arrested for breaching the Capitol and now wants to be on the school board or something like that. So the answer is unclear, but it's a practical matter. It solves the question definitively, if we say, and in a nationwide way that doesn't actually impact the rest of Section 3 of the 14th Amendment. And to me, that's its primary benefit. It's uncertain, but it would be clean and surgical, though a victory for Trump.
Professor Manheim, assuming that we could agree on what it means to engage in insurrection, and assuming that we could agree on whether the provision applies to the president or a candidate for the presidency, does Section 3 of the 14th Amendment automatically bar insurrectionists from taking office, or does some other entity or something else have to occur first?
Yeah, so one quick thing just to sort of put a pin in it or sort of flag it here. So you keep asking, if we all agree on this, if we all agree on that, and essentially that's what the Colorado majority had to do below. And that's what Colorado now has to do before the US Supreme Court, in a sense, to win. So they need to have the Supreme Court say, yes, we agree with you on this. Yes, we agree with you on that. Yes, we agree with you on this third thing. And basically, if the US Supreme Court disagrees with them on any of these steps, then that means the Colorado Supreme Court case gets overturned. So and you're making that reference to the skiing?
Yeah, like
I don't know if
boom, boom,
yeah.
boom, and at any point the helicopter could remove you,
or you
then you're down in a lodge.
Right? Yeah. Okay. So, and actually, for what it's worth, I will say that the more I look into this, because you can look into it for an indefinite amount of time. There's no like Professor Porter said, there's no narrowing of the question presented. There's a million issues that have never been answered. So you can look into it forever. But the more I look into it, actually, each of these steps seems less problematic to me than I thought they did, which is to say that the Colorado Supreme Court's opinion seems stronger to me the longer I look into this. That being said, again, to repeat myself, they have to run the table. So they have to win on everything in order to get the case upheld, which is one of the reasons why I think it probably won't be upheld. But so the next question, right? So if we agree on insurrection, we agree on the facts as they apply to Trump, we agree on that it applies to the presidency, we agree that it bars, running for the presidency, et cetera, et cetera, et cetera. Then there's this question, hey, wait a second. Does Congress, here the question is Congress, does Congress need to act before any of this applies in the first place? The phrase that's often used here is self-executing, but I don't think that's very helpful here for what it's worth. One way of thinking about it is this. You look at this thing and you say, this is kind of like a treaty where it actually doesn't kind of enter into law until Congress has defined it in some way. That actually doesn't make a lot of sense to me in this context. That's just not how the Constitution generally operates. I think the stronger version of this is, ready? This just doesn't really work very well unless Congress has set up some procedures for us. And so we think as a matter of structural constitutional interpretation that the best way of understanding this provision is that there can't be any processes by which somebody is barred from taking office until Congress has set up those processes. Now, here's the thing. If you really lean into a structural argument, or even go further and you almost make like a purposivist argument, and I'm sorry, I'm throwing around jargon. Let me put it this way. If you're not a textualist, then you might say, yeah, that actually makes some sense. How are we supposed to do this? Particularly with a presidential election, this makes no sense. So we just don't think it should work that way. So we're going to interpret it as not working until, not doing anything until Congress acts. I actually think to me, there's some intuitive appeal for that. It's such a mess. But I think if you look at it textually, you just don't see that. It just applies. You're barred. So there's not agreement on that. There is the last thing I'll say about that is that this is definitely going to be a big issue before the U.S. Supreme Court, in part because the implications of ruling on this basis are very different than the implications of ruling on whether or not it applies to the presidency. If the Supreme Court concludes it doesn't apply to the presidency, that answers the Trump question, but then the states can all do more work with everybody else. If the Supreme Court decides it on this ground that Congress needs to act, let me tell you something, Congress is not going to act. So that means that the 14.3 does nothing.
Sounds like there'd be a lot of appeal to a resolution that allows the court to simply blame Congress for the problem.
This is why I predict that will be the ground on which Supreme Court rules.
Professor Porter?
I just wanted to note that because you're probably studying this in constitutional law, some of these arguments basically say that another portion of the 14th Amendment, Section 5, which empowers Congress to actually make laws, right, to enforce the 14th Amendment, comes into play here on the side of the argument that there should be congressional action here. And I have to say, I agree with Professor Manheim. Like, I think it's a practical matter. I don't think it's a good idea. I don't read the text this way. This provides actually a rule for Congress. 2/3 of Congress can actually remove a disqualification. Also, the 13th Amendment, which prohibits slavery and involuntary servitude, also contains Section 2, the language of which is exactly the same as Section 5 and the 14th Amendment. And I don't think that needs to be done pursuant only to an act of Congress. I think it's self-executing.
So Professor Lombardi, we now know that Section 5 exists. Congress is authorized to enact legislation. We know that Congress has never done that, correct?
Has never enacted legislation to define.
Right. Okay.
It has enacted legislation to provide a process by which people are to be. Were you already going there?
Yep.
I'm sorry. Never mind.
You're good. You're good. Well, why don't you weigh in first on whether you have what your view is on the significance of that feature of this case, the failure of Congress to act. Do you share the view that we've heard that this may wind up being defining?
I think it's deeply problematic for exactly the reasons.
Get a little closer.
Oh, sorry. I think it's deeply problematic for the reasons that Professor Porter alluded to. We've now violations of due process, for example. So the 14th Amendment creates a due process clause. You have a right to not have your due process violated. Now, there are certain statutes that give you causes of action to bring suit against someone who has violated your due process. On the other hand, we never say that your right to due process simply doesn't exist unless Congress has already spoken. And as a defense to being prosecuted, you can raise a due process claim even in the absence of a cause of action. So cause of action allow you to bring suit against someone else, but you can always defend yourself on the grounds that what's being done to me is a violation of the Constitution. We'd never want to get rid of that. And so Section 5 can't obviate a right or a disability simply because if we were to read Section 5 as necessary in the Section 3 context, you'd have to read it as necessary in the Section 1 context, and nobody wants to do that.
And of course, Congress could take the position that this amendment is crystal clear. We don't need to act.
They could
duck it entirely.
But in the 13th Amendment, I don't think we'd want to say that you can be enslaved unless Congress decides to write a statute to reify that.
Okay, so I'm going to ask one more question because I want to leave time for questions from everybody else. And it's open to any or all of you to comment since you all have had professional experiences with people who either did or wound up serving on the Supreme Court. So when I think about this, in some ways, it seems like there's a part of this case that could nudge justices away from what we think of as their natural positions. And what I mean by that is that justices who traditionally have favored an evolving, living constitution may actually wind up gravitating toward a textualist position. This says what it says, let's hang it around his neck. And justices who normally adhere to an originalist or textualist position might view a move to a more flexible view of this provision as an appropriate way to resolve the case. So I know none of us has crystal balls and we don't really know what's going to happen, but what is your sense of what we're going to see in the way of a resolution here? And significantly, I mean, we all can assume that the Chief Justice will work very hard to get this decision to be embraced by as many members of the court as possible. Is that going to happen? Are we going to see a 6-3 or a 7-2 decision? Professor Porter?
So if I were John Roberts, I would want a per curiam opinion, which is say unsigned. I'd really, my dream would be for Justice Thomas to recuse himself. Then I want an unsigned per curiam opinion that was not that long and as boring as I could make it. I would just want it to be dull and technical. And I would want you to read it. You have to read it in con law and you'd be like, yeah, I get it. The answer is no. The problem with answering yes, that he can be disqualified here. The practical problem is, what's everyone going to do? So like there's different models of judging, right? There's the model of judging that's like, we have to just come up with the right legal answer. That's what we think about judging, the conventional model. And then there's kind of more ideological models that posit that judges are actually trying to, whatever method of interpretive method they use, are trying to actually kind of enact their sort of ideological preferences. And then there's just pragmatism. The country has to operate. So a few of the, very few, like there's 1 or 2 amicus briefs here filed by the court by election officials in different states that are just like, look, I don't care. I just need to print these ballots. Do I put his name on the ballot or not? It's expensive to print ballots. And in the election context, that's totally a factor to consider. So I think the ideological rulings of the justices could bend here, partly though, because when the Constitution is living and breathing, it's kind of developing over time. And here we don't really have any development. We have sort of nothing for 100 years. And Trump is pressing constitutional boundaries as he has during his presidency in so many different ways that there's not like a good record for it. But I also think just pure pragmatism in an election year at a time when everything, in addition to politically sensitive, is just practically messy, counsels in favor of arguing no here on a dry technical group. Hopefully, I don't know how they get Sotomayor unless it's just really narrow. That's the problem. I don't know if it can happen.
I don't know what's gonna happen. What I would say is that I would be very, very surprised if the US Supreme Court upholds the Colorado decision. I mean, it might, I don't know. I would be very surprised if it did. And if it upheld that, to go back to like the election law wonky stuff, all that decides for, well, it depends on, that's the thing, right? So it depends, I guess if I'm sort of thinking out loud, it's just a mess. It's just a mess. Like Trump will still be on the ballot in most states, in the primaries and probably in the general. And so he could win the election still with this Supreme Court ruling, saying that he is, I don't see how they can, unless they did something really weird, which they might, who knows, that's the thing. No one knows, nobody agrees on anything. But unless they did something very strange and essentially said, we're going to affirm the Colorado decision without concluding that ultimately Trump is ineligible, which would be very hard for them to do. Then if they conclude that Trump is ineligible, then to repeat myself, I think he would appear on most of the ballots. He could, in theory, win the election with this Supreme Court ruling saying he's ineligible to take office. So that's a mess. And then if you go and you ask, okay, well, if they say no, we're going to reverse the Colorado Supreme Court decision, on what grounds are they going to do it? Here's the thing. We could talk all day long about what the best legal argument is, but I think the justices are going to be figuring out not what the best legal argument is, but instead what set of consequences is the best. And it really matters if they decide president is not included, if they decide this has to be self-executing, if they decide Colorado just messed up Colorado law, the consequences of these different types of holdings are very different. So I don't know. I think that you and I think that saying the president is excluded is probably the cleanest. So they might go with that. That doesn't read well on the cover of the New York Times. It's not going to look good for the Supreme Court. So they may go instead with Congress needs to act here. If they do that, then I think that adds another layer of complication going forward. So there's no clean answer here.
You know, over the last 5 years, I have realized I'm a very terrible predictor of what courts will do, what Americans will do.
Tell us your prediction, and we'll just assume the opposite.
I mean, I really don't, I don't think it's impossible to, and this is the only, I think it's unlikely, but I don't think it's impossible that the court would decide to defer to Colorado on a question of who can serve on a Colorado ballot. When I say it's not impossible, it may be very unlikely, but it's going to be a real gut check for some of the justices, because as you say, to get to a different conclusion will force some of the justices to go so far out of their out of positions on which they have lectured other people at length and have staked the legitimacy of their own opinions, that I think it's going to put them in a very awkward position, and thus leaving open.
Who's the justice appointed by President Trump most likely to adhere to his textualist ideology?
I would think probably Justice Barrett, but I'd like to hear my colleagues.
I'll take Gorsuch. You want Kavanaugh? I know you got Gorsuch. Okay.
I'm with Gorsuch too. Okay. So I have another question too, but I want to pass the mic around if anybody has questions before oh, looks like we have questions. Okay. All right, Sam, you're closest. You get to ask the first question.
Kind of just a clarification, I guess, with the debate about like whether Congress needs to act with the self-execution. Where does that play with just kind of considering it like is that functionally a political question, like saying that because they're not necessarily saying that they don't have like jurisdiction over it like it would be with a political question, but that politics has to act first. So I didn't know if there's like an exit ramp for just saying political question, we're not touching it.
Well, here's the other thing. The federal political question doctrine doesn't apply to state courts anyway. So my understanding is that it's more the political question analysis would help to, in a sense, support the conclusion that the purpose or the intent or whatever you want to call it of this amendment was not to have courts just start ad hoc doing this. So stated otherwise, when we say that can't possibly be what the founders intended, one of the explanations for why we reached that conclusion is that, do you see how hard it is for courts to do this without congressional guidance? We see, in a sense, an analogous argument in the context of political question doctrine.
Walker?
Thank you all for doing this. I think this is a question for you, Professor Manheim, though maybe it ends up touching on everyone. First part is, how often do office exclusions like this get used to keep someone off the ballot as a matter of election law? Meaning, hold any office is different than be on a ballot. The follow-up implication just being, how likely do you see the off-ramp really being almost a ripeness thing, where it's not about being on a ballot, it's about holding an office. So two-parted.
So you're not asking necessarily about 14.3, but you're asking like, are you 35? Have you paid the filing fees? Do you have the signatures?
Totally, because
Yeah.
we heard how Congress has kept people from being seated, but yeah.
Yeah. Okay. So this question in a sense goes back to what you were saying, where some secretaries of state are filing amicus briefs where they're like, the deadline is Friday. The printers are really getting frustrated with me. Just what do I put on a ballot? And so those folks, here's the point. Those folks do this all the time. That's their job. There's a whole block of cases that are referred to as ballot access cases. And those are just the big ones. This routine stuff happens all the time. And again, just to be a little bit more concrete about it. So if you want to get on a ballot, you don't get to be on a ballot just because you want to be. You have to comply with the state rules allowing your name to appear on the ballot. And the state routinely kicks people off for not complying with the rules, including if the state has, with respect to something like the presidency, if the state has a rule saying that if you're ineligible to be president, then you can't be on the ballot, then they're going to not allow someone on the ballot because they're ineligible. Again, they're not old enough, they weren't born in the United States, they don't live, whatever. One final thing, and then I'll stop talking. Here's the thing, there's also precedence for one state declaring someone to be ineligible for being too young and excluding that person from the ballot, and another state not engaging in that same analysis because it wasn't in that state law, and so that person appearing on the ballot. So to go back to what I said before, even if the US Supreme Court affirms here, we don't have a situation where Trump is off the ballot in all the states. That's just not how election law works.
Somebody else have a question?
Oh, but if I could just add one thing to Walker's question.
Sure.
The text of section 3 really talks about holding office, not running for office. And so there are a bunch of arguments basically saying that your point, Walker, isn't just a matter of state law, but it's actually a matter of this constitutional provision, that this doesn't actually speak to running for office at all. And that would be a different ruling, right? Because then it would leave this question of unqualification of Trump just like up in the air for other people to deal with later.
Obi?
Yeah, thank you guys for doing this. Professor Porter, you brought up the question of practicality a lot. I was wondering if you think it'll play into the court's analysis that ultimately there was slim to no chance of Trump ever winning Colorado in this election, and whether or not that could be like, okay, he's off the ballot in Colorado, but like that's not ultimately going to have an impact on his access to office.
So I agree with you. I think his chances of winning in Colorado are low, but I think that their pragmatic interest will sweep more broadly than that. What's going to happen during this electoral cycle? So if anything, if the court decides anything where the answer could go either way, then you're going to have 50 different states having basically emergency proceedings now. And some of them will be done by the secretaries of state, like in Maine, some of them will be done, like it's just going to be a little bit of electoral chaos. So I think the pragmatism, to me, it sweeps more broadly than that. It's like actually Donald Trump's best argument. Like, it's like this, like, I am the embodiment of chaos. Get rid of me now, right? It's very effective.
Can you pass the mic down? Thank you. This will probably be our last question. Either way.
Another question for Jeff, but go ahead. Thanks, I'm sorry. Yeah. Hey, hello. This might be a little bit out of left field, but in some of the briefings, Trump brings up this double jeopardy principle, and not the hard rule, right? But kind of argues that although he might have been committing insurrection and prosecuted under those kinds of grounds by the Senate in that impeachment trial, it can't affect these proceedings here. And a lot of historians think, well, this is a really weak argument because the context is that disqualification is a form of punishment, but it's not like a criminal prosecution. What do you make of those arguments, and do they hold any ground?
Double jeopardy, Professor Lombardi? Yes, no?
No.
No, here's your answer. Nope. I guess we have one more question. That was good. I don't think anybody disagrees with that. Good. Last question.
Can you hear me? I don't know.
No, is the green light on?
There's no light on. Oh, there we go.
There.
Sorry about that. So knowing how the courts responded to a lot of emergency actions around elections in 2020 and like this chaos thing that you're talking about, do you think it's possible that the court just like punts on all of these substantive issues and like cites like the Purcell principle that like this would be too much chaos, we're not going to change the expectations of the election, and just like not answer any of these questions?
I think the court wants nothing to do with this. And I think if the court could just make it go away, the court would make it go away. Don't see an easy out for the court. And I think that if the court were to cite the Purcell principle, the people in my world, like their heads might spontaneously just explode. I think the short version of my answer to your question is this case was brought quite early in the election cycle. So to say it's too close to the November 2024 elections, I don't know if that would make sense even under the Purcell principle, which is a pretty flexible principle. But your intuition, I think, is correct, which is that the court does not want this case, but they have it.
All right, so our time is about up. Please join me in thanking our panel.